Okay, welcome to session 6. This is going to be a little more meaty, okay? So make sure that you're paying attention and know that, we've been going for a while here, but you're doing good. Okay, we're at the top of page 16. Things you may need to include in your petition for divorce. Because you're like, okay, I got these forms. How am I supposed to know what I'm supposed to keep in there, what I'm supposed to take out? Okay, so let me demystify this for you. First bullet point says there will be basic forms to use at the law library that may meet all of your needs. They may meet all of your needs. But if not, there may be special things you may want to make sure you ask for. And a lot of places will say, well, if you didn't ask for it in your petition for divorce, you're not going to get it. So you want to make sure that you're asking for everything that you think that you may need, even if you ask for too much. You're not necessarily, this as long as they're in the documents themselves, you may decide, I'll let that go. That's not so important to me in the grand scheme of things. But just in case you decide later on for one reason or another, oh yeah, that really is important. You'll have it that you officially asked for it in your petition. All right. So it says, one of the special things, the first sub bullet point there says, husband is from another country. Is your husband from another country? There may be certain things that you want to ask for your petition for divorce, making sure that they are special provisions that you might want if your kids are going to be traveling outside of the U.S., who can apply for the passport for the kids if you don't have one already. Those types of things. If your ex was talking about, well, you know what, I don't know if I'm going to return with the kids, from wherever they're from. If you're having those types of issues, you want to make sure that sometimes there are, especially in Texas, there are provisions in there about parental kidnapping and things like that. But usually if you're having or thinking about those types of issues, then you probably need an attorney. It may not be wisdom for you to continue trying to represent yourself. Or if you do, try to get as far as you can representing yourself and then get an attorney through some point in the process where you say to yourself, okay, I need to get an attorney now. Okay, the next sub-bullet point says, do you have property you owned before you were married that you still have today? Or another thing is, did you inherit property while you were married? In a lot of states, I would say probably in most states, when you inherit something, whether it's property, money, things like that, even though you're married at the time that you received it, at the time the person passed away, it is still considered your separate property. And that's true here in Texas. You inherit something from parents, uncle, aunt, grandparents, doesn't matter. It is your separate property unless you do something after you receive it that was called commingling. So in other words, if your dad left you $100,000, and instead of when you received that $100,000, you didn't put it in a separate account in just your name, you put it in a joint account. That's called commingling. Or your dad left you a house and you decide, you know what, I'm going to put my husband on the deed. I know. But so if you do something like that, that's called commingling, and then things get a little messy. But otherwise, even then you can usually trace, how did this property become property? Then you start arguing over whether at the time that you put his name on the deed or that you put the money into a joint account, did you mean for it to be, 50% gift to your husband? Then it starts to get a bit complicated. Again, if you're fighting over that, then you probably need an attorney, at least at that point. You probably want to get one involved. Okay. So if you had property or that you inherited, or if you had property before you got married, you want to ask the court to confirm your separate property, to recognize, and confirm this means recognize that you had separate property. So that way, there's no confusion about that. Or do you want to, the last bullet point on that, on page 16 is, do you want to change your name back to your maiden name? Sometimes, some women do that. A lot of times if you have kiddos, especially if your kids are still in school, it is just easier to just keep your married name. Because you figure, okay, if I get married again, my name's going to change anyway. So right now it's just easier to get things done for school and, you know, all that business, doctors and all that stuff, if I still have the same last name as my kids. And some people think that it helps the kids transition through the divorce easier. Next page, top of page 17, we're talking about now temporary hearings. You know, sometimes you may hear about that. You know, what is a temporary hearing? You know, how do you know if you need a temporary hearing? And a temporary hearing, the purpose of it is, you know, you can't wait until a final trial date 4 months out. You know, you're afraid that money's going to start to be switched around. You're afraid that, you know, you're arguing over who's going to stay in the house, those types of things. So if you have those types of issues pop up, you need temporary orders in place while you guys are working out all your issues within your divorce. So that way, you either make sure that you maintain the status quo, you maintain the way things are right now. That's really the purpose of a temporary hearings. And we'll get into right now, how do you know if you need a temporary hearing? Okay, the check mark number one, the first check mark I should say, situations where if you wait, you will suffer loss that you're not likely to recover. Like if you think your husband's stealing money, you know, putting money in somebody else's name, things like that, hiding stuff, your family heirlooms, you think he's hiding that, you know, whatever it is. I mean, again, if you think he's really hiding a lot of money, then usually if you have those types of assets and you think he's really, you know, trying to steal that or keep it from you or hide it, then again, you usually probably need an attorney at that point. The next check says you won't get any child support from your husband unless he's ordered to do it. So, you know, if he's one of those, you know, if you don't want to stay married to me, I'm not going to pay you a cent and da-da-da-da-da, you know, if he's starting with that, then, you know, you probably need a temporary hearing so you can get some child support. Next check mark says husband is talking about taking the kids away from you, or there's some type of dispute over custody, some type of argument over custody, or even visitation. You know, if you feel like something, okay, you know, we're not going to work this out, we need some temporary hearings. And then again, you know, you may need an attorney for that. Some people will actually go to the Attorney General's office, especially if it involves child support, and they will be able to get relief that way, even though the Attorney General's office does, you know, usually most of the time, in my experience, both in New York and in Texas, you know, they have a lot of cases and they're just slower. You know, it's slower to work through the system. Okay, the next one says, if you need to sell property like your house while the divorce is pending, and you can't come to a written agreement on your own with your husband. So say, for example, neither one of you can really afford the house anymore, and, you know, you're starting to say, you know what, I don't know how either one of us is going to, you know, do the mortgage thing here. You know, if I'm moving out or if you're moving out, you know, if he's moving out, whatever it is, if you really feel like you can't afford the house anymore, you need to sell it, and you're not divorced yet, that's a reason to have a temporary hearing. If you need access to money right now to live on, and you need permission to sell an asset or to invade or go into a retirement account. Again, if you can't come to a written agreement on your own with your husband, then you need a judge's permission to say, yeah, you know what, I need to dip into this 401k because, you know, as we're trying to figure things out and dividing everything, you know, I need some money to live on. And so if you find yourself in that situation, then yeah, you may need temporary hearings. Last bullet point here says, if you're not sure, it's better to include a request for temporary hearings in your petition so that you will have it if you need it. If you don't have to schedule a hearing until you need one. So, you know, they may be in the form, they may be, you know, there paragraphs or provisions in there that you can stick in there for a temporary hearing. And, you know, you don't have to right away set one, you know, but you'll still have it in your petition for divorce, you know, a request for temporary hearings just in case you need it. So that way you don't have to, you know, edit a new, you know, some people say you would have to file an amended petition for divorce to include the temporary orders, or a separate document for a motion for temporary orders. That way you just have it all in one document. You don't have to, you know, try to edit and figure out what else you need to do. It just makes it easier. You have it just all up front. Page 18. setting a temporary hearing if you need one. Okay, so say for example, okay, you fit one of those criteria. He's saying, you know what, I'm not giving you a penny. You know, I'm upset about what's going on, and right. Okay, so bullet point number 1 says old school courthouse. Old school courthouse. Checkmark number 1 says have a calendar on hand with you at the courthouse. It can be your smartphone or whatever you normally use for a calendar. So if you normally use your smartphone as a calendar, then you have it with you. If not, if you have a hard cover book or soft cover book that you use to write down and schedule everything, then absolutely do that. Some people use kind of like a diary to schedule everything. Whatever it is, doesn't matter. But bring one with you so you'll be able to look at dates. Have dates in mind for the next 2 to 3 weeks from the day you file, and type them on a piece of paper with the heading dates petitioner. Petitioner is you, the person who's filing. Dates petitioner is available for a temporary hearing, and give it to the clerk when you file the papers. Okay, and you're doing that because you'll know in a second. You won't be able to go back and talk to a court coordinator who's going to set your temporary hearing. So you need to give them a piece of paper and say, look, this is when I'm available. Okay, so that's what you're doing that for. Okay, it says, the next check mark says, the clerk will send your file up to the court you've been assigned to. Okay, so you've gone, you filed your papers, you've got your request for a temporary hearing on there, and you filed it, and you get a court that you've been assigned. Again, it's random, and now you need to set a temporary hearing in that court. So the clerk will send your file up to the court you're assigned. Next check mark says you will usually have to go to the courtroom you're assigned to speak to the court officer, and tell him or her that you need a temporary hearing date. So you'll come in, and most of the time the court officer will motion you over and ask you, okay, how can I help you? What do you need? And you'll tell them, okay, the clerk sent up my file. I have a sheet of paper in there. I need a temporary hearing. I have a sheet of paper in there that tells the judge, or the court coordinator rather, when I'm available for a temporary hearing. And usually temporary hearings are 2 to 3 weeks out. So that's why I told you to pick those dates. Okay, next check mark says the court officer will let the court administrator know, and he or she will set a date while you're waiting in the courtroom. So, they say, okay, let me see if a file is back there. They'll check to see, and they'll set a date. And the next check mark says, once it's set, you'll have to go back down to the clerk's office to get your citation and notice of hearing, which will also be an additional fee. So if you're asking for temporary hearings, there's usually an additional fee for that. And again, you'll find out what that is on the court's website. And so the citation will say, you're being sued. And not only that, the citation will also have a notice of hearing, which makes sure that your husband knows, hey, not only has my soon-to-be ex-wife filed for divorce, but she also set a hearing date. And so, again, there's a little bit of additional fee for that. Now, the last bullet point on page 18 says paperless courthouse. Okay, the only difference between that and usually in a paperless courthouse is that you won't have to wait for the file to be sent up, because it's already there digitally. The court officer will ask you, what's your name, or sometimes you'll have a sheet of paper that the clerk will give you that gives you the file number that you've just been assigned. And you'll probably just give them the file number, and they say, okay, the judge will then pull it up, or the court coordinator will pull it up on their computer and see that you filed and see that you need X, Y, and Z, whatever you see you need a temporary hearing. You'll still hand the court officer your piece of paper saying these are the dates that I am available. Okay, I know that was a lot, but you're doing good. That was session number 6. Take a deep breath. If you need to go back over the workbook and look it over again while it's still fresh in your mind, absolutely do that. But you are doing so good, and I'm so proud of you. Let's move on to session number 7.